All right. Hear ye, hear ye. The first court of appeal is now open. All that business in support are on here. Give attention, you shall be heard. God save the United States, the great state of Florida.
Please be seated. Okay, the first case on the docket is Smallwood versus State. Welcome back, Mr. Sheriff. Twice in 1 week. Okay, for the other appellant, when you come up, if you want to save time for rebuttal, please let us know, but you're ultimately going to be responsible because the clock will be right in front of you. Okay, you may proceed.
Thank you, Your Honors. I'm Barbara Basheras, representing Cedric Smallwood. I'd like to reserve 5 minutes for rebuttal. Your Honors, Mr. Smallwood is seeking reversal of an order that allowed the warrantless search of his cell phone in a trial for armed robbery. The basis for allowing the search, Mr. Smallwood believes, was flawed because the court relied principally on an analogy between a cell phone and a container. And it's our contention that a cell phone is not a traditional container, as that term has been used in the development of Fourth Amendment case law. Instead, a cell phone is a different kind of device, similar to other electronic devices, that stores digital information and, depending on the type of phone, links to additional digital information.
Okay, there's federal case law out there, though, that talks about a wallet, date books.
Yes, Your Honor.
How is a cell phone necessarily, I understand it covers a lot more different things, but how is it different from a date book or a diary even, let's say?
The difference, Your Honor, is that it can be a date book, a diary, a photo album. With the increasing storage capabilities of cell phones, it can be a record of Internet transactions. It's also increasingly a camera. Camera phones, as in this case, are very common.
How about if this person just had a traditional photo album on their person at the time they were arrested? Could that have been searched?
If they had a photo album under their arm, so that it was
either under their arm or a small one in their pocket?
Probably that could be searched, Your Honor. A wallet can be opened and items in the wallet looked at.
Okay, then help me. Okay, when I pull the cell phone up, there's a thing that says photos on there usually. My iPhone has a thing that says photos. If I can search a photo album, why couldn't I at least search that part of the cell phone that says photos?
Your Honor, because of the breadth and quantity of types of information that can be stored or linked to a cell phone, it's our position that it's improper to allow the police to start looking in a cell phone because...
But in this case, the photos were on the phone. They didn't...
Yes.
The officers didn't, go to the defendant's Facebook page and look at those.
And in fact, there's even a higher expectation of privacy, we would argue, in photos that are simply taken on the phone and left on the phone than photos that might have been disseminated through some other means.
Mr. Sheriff, let me try and propose an analogy to you, and you tell me whether you think it's apt. Suppose a woman was stopped as a suspect for a robbery. She's arrested. She has a purse. In the purse are one of those fold-out containers of photos that women can carry because they have purses. Men can't because there's not enough room unless they have one of those man bags or whatever they call them.
The European shoulder bag.
Yeah, whatever. But in the purse, she's got this fold-out thing of photos. She has an address and telephone, one of those little books that includes telephone numbers and addresses. And she has a bunch of receipts for prior transactions, including her long-distance phone bill. Is there not federal precedent that would authorize the police in a search incident to arrest to look at all of those things?
Your Honor, there is, but...
Well, is that an apt analogy then or an inept analogy, inept. And I have to tell you, I have considerable sympathy for your position, so I hope you can explain to me how we avoid all this law that seems to go the other way.
The difference, Your Honor, is that the purse you're talking about, or bag, or any other device, carrying device, is a physical container that contains physical objects. And there is a limit, just a physical limit, to how much one person can carry around with them. Even the largest purse, is limited in the number of pictures of one's.
So it matters
for a large purse.
Plus, does it matter because the photo album may have 500 pages versus 5 pages? It's the same kind of intrusion.
The nature of the information is still different, Your Honor.
Okay, but if the question I get back to you and ask, I understand, diary on a cell phone, bank records, traditionally things that you can't carry around with you, like photos in a wallet. Mm-hmm. But unless you go into those other items, why is that a problem here? So, if I go on my iPhone, there are parts of my iPhone that have, apps that put diaries on there, notes on there, various other things. But if you're simply looking at the photo album, the address book, aren't those things that the courts have said that can be searched?
The problem, yes, Your Honor, those things in the appropriate physical circumstances have been held to be validly searched. But the difference is that these are not physical items that could be taken out of the purse and put on the table, that could drop out of one's pocket. They are digital images and digital information.
But it's still the same information. Are we protecting the item based on the nature of how it's stored versus protecting the item itself? It seems to me that our concern is more to the nature of the item versus, the mechanism under which it's stored.
I understand, Your Honor, that if somebody is arrested with a handful of pictures in their pocket and the police pull the pictures out, they will necessarily see what is on those pictures. The difference here is that if you have a cell phone, you don't necessarily see what's in the cell phone or that to which the cell phone gives you access until you start manipulating the cell phone.
Okay, why wouldn't it be a better, and I understand your argument about manipulating the cell phone, although, again, my iPhone, right there, says pictures and contacts, so you don't have to do a heck of a lot of manipulation. Why isn't it a better view to say if somebody wants an increased level of privacy, they would password it? Because I can password stuff on my phone.
Certainly that would demonstrate an increased expectation of privacy, but it shouldn't be necessary. Because as some of the courts that have looked at this have realized, particularly the Ohio Supreme Court in Smith, the breadth of information that's available from a single small handheld device has become so wide and so extensive that allowing unfettered access to that simply goes contrary to the Fourth Amendment.
Well, let me try to help your argument here, throw you a softball. The U.S. Supreme Court, unless I'm aware of something, the U.S. Supreme Court has never addressed a date book, a wallet specifically, or a cell phone, have they?
No, not
Okay, are we bound by anybody else other than the U.S. Supreme Court?
no, Your Honor.
Okay. Then address the Jenkins case and that, with the background that I just gave you. Address the Jenkins case to me and make your argument.
The Jenkins case.
The Jenkins case is the Florida Supreme Court case that talks about a balancing test of the need for the, as I read it, as the need for the information, even on a search incident to arrest, the balancing test of the need for the information versus the expectation of privacy.
And the degree of intrusion.
Yeah, the degree of intrusion
corresponds to the expectation of privacy. Under that approach of looking at the need for the information versus the degree of intrusion, which is not exactly the U.S. Supreme Court test for a search incident to arrest, but the need for the information...
Okay, stop right there and then we'll get to that, because you just raised another issue. We are bound by U.S. Supreme Court interpretation. Is Jenkins consistent with U.S. Supreme Court interpretation of search and seizure? Of a search incident to arrest?
It's not our position that Jenkins is directly inconsistent with that, but that it perhaps doesn't completely take into account the dual rationales for a search incident to arrest that were reaffirmed in Arizona versus Gant, and go back to the line of cases to the Chamel decision.
Okay, it goes back to the reasons for a search incident to arrest.
The reasons for a search incident to arrest being either the preservation of evidence or assuring officer security, making sure that there's not a weapon or something that could be used to injure the officer or to effect an escape.
What about United States versus Robinson?
Yes.
Robinson seems to suggest that a search incident to arrest is permissible simply by virtue of the arrest, and that officer security or the likelihood of finding evidence of the crime is more or less irrelevant.
Your Honor, that's correct. It's one reading of Robinson, when it's limited to a search of the person, it has been applied in a number of situations, a number of cases, to say that once you're arrested, you have no expectation of privacy in your person or in items immediately associated with your person. And our position would be that a cell phone should not fall into that category of items, again, because of the size of the extent of the information it can contain. It's simply not analogous to another container or another piece of information that could be physically stored in a pocket or in Robinson in a pocket of a jacket.
But the cell phone was on your client's person when he was arrested.
Yes. Yes. And Robinson was decided, I want to look to make sure.
1974.
74, where cell phones, mobile phones, the type of electronic devices we have were literally science fiction. There's simply...
Okay, well, cell phones that would hold information like that, maybe, but we had those big, clunky...
Right, there were mobile phones, Your Honor, which at the time were heavier than the laptops of today and had to be, carried around with a handle. So the technology has simply changed so much that to assume that a cell phone or another portable electronic device comes within that scope of Robinson as items that are intimately associated with a person basically deprives anyone of an expectation of privacy.
So you would say, look, times have changed in a way so dramatic that the Supreme Court, even maybe as recently as 5 or 6 years ago, really couldn't have contemplated this sort of problem when it was dealing with search and seizure law, and maybe ought to go back and rethink it.
Exactly, Your Honor. And in fact, most of the cases that we've cited in our briefs to you that actually deal with cell phones, analogous to the phones of today's capabilities, have just been decided within the last few years. So this has never been an issue that's reached the U.S. Supreme Court.
Okay, the Ohio Supreme Court directly decided basically in your favor.
Yes, Your Honor.
But all those other cases that have been on cell phones seem to me to be, as you point out in your brief, a little bit different, because there was some indication that there was some evidence that could be on the cell phone of the crime that the person was arrested for.
Yes. And I think there's two main differences between our situation and the cases that have ruled in favor of allowing the evidence. And one is that most of them accept the container analogy. They treat a cell phone as a physical container, like the package of cigarettes containing heroin was, I believe, was that Robinson or Belton? Robinson.
I am having a little problem, though. I
Yes.
mean, going back, and help me one more time and give me another answer. In your expectation of privacy, or are we looking at the type of information we're going to protect or the manner it's stored. And that's I guess, my hang-up a little bit.
Yes, Your Honor, I would say that it's both. It's both the type and the manner in which it's stored. But when the manner in which it's stored lends itself to such wide-ranging intrusion into someone's personal information, then it would be stopping too soon just to look at the nature of the information and say, well, this is a digital photo, we can treat it as a physical photo, or this is a digital list of addresses, so we can treat it like a small address book. You have to look at the cell phone sort of in its entirety and the capabilities that it has to say that allowing the police to simply go into that when there's no connection that's been articulated between the phone and the crime is going too far.
Okay.
So your position is, when the defendant's arrested, law enforcement can seize the cell phone, of course, but they can't open it and manipulate it and see what's in it.
They can preserve the cell phone, yes.
Okay.
We're not arguing that they can't seize the cell phone and physically keep it.
Well, some cell phones close, and they have a screen when you open it you can see, and a smaller screen on the outside. And if someone calls, you can see their number. If someone called during the time of the arrest, they got the cell phone in their hand, can they look at it and take note of that number of the person that's called?
At that point, which is not at all the situation that was factually in this case, you might have a plain view type of exception that could be argued at suppression.
Yeah. Your position is that officers can't look on the cell phone.
Correct. What you're indicating is that there might be some other reason for looking at the cell phone. There might be also an exigent circumstances reason for looking at the cell phone. My rebuttal time is running out. I wanted to answer.
Well, I have another question, too, but
Yes,
go
sir.
ahead.
You know, there is another case pending in this court, which there was some indication on the record that the cell phone could be a weapon, because now evidently they're weapon devices. And the only way you can determine whether it's a weapon or not is to open the cell phone. Now, those aren't the facts of our case, and that wasn't the reason for the search here, but should the officers be able to get at that, should they have been able to conduct a search in that case?
Under traditional search incident to arrest principles, because of the need to assure officer safety, if there's a reasonable basis to think that a phone could be a weapon, then they would be justified in going so far as was necessary to make sure that they were not in danger from the phone.
Okay. You can answer Judge Wester's question, because I'm going to give you a little more time, just because of the significance of the issue.
Thank you. I'm sorry, Your Honor, could you repeat your question?
Well, I haven't asked it yet.
Well, that explains
I
that.
know they've been coming at you fast and furious, but I assume, as I understand the facts of this case, the arresting officer had no real reason, no articulable reason, to suspect he would find evidence of the crime by searching the cell phone. Is that correct?
That's correct.
If the officer had articulated some reasonable basis for suspecting the cell phone might include evidence of the crime, would you, I take it, agree that in that circumstance a search would be proper?
Your Honor, I believe we've argued in the briefs that in a situation where there is a nexus between the phone and the commission of the crime itself, so that it's reasonable to believe that there's evidence of that crime on that phone, that a search incident to arrest could be permissible. And that's actually been the factual situation in the great majority of cases where this issue has been raised. Almost all of them have involved phones that were being used either in arranged buys or drug trafficking, where the phone was an instrument of the crime.
And I understand you use the term nexus with the crime, but let's suppose we had a modern-day Bonnie and Clyde, which apparently your client seems to approximate in some sense anyway, in the sense that they like to take pictures of these things. And instead of having a photographer follow them around like Bonnie and Clyde did and take pictures for newspapers, they took their own pictures on the cell phones and sent them to the newspapers. Can an officer arresting a suspect in that situation look on the cell phone to see if there are pictures?
Your Honor, if the officer knew that pictures had been sent from that phone to the newspapers, that might affect our analysis of the expectation of privacy in the pictures. But absent that knowledge, at the moment of arrest, I don't think that would give the officer reason to go into the cell phone, simply knowing that people often take pictures of themselves, which they increasingly do.
So for your hypothetical, if the officer knew that this defendant sent pictures of either evidence of the crime or the crime in progress, the officer knows that, could the officer obviously could go in and look at pictures? Could the officer look at their email also?
No, Your Honor. It would be our position that the connection between the phone and the crime would define the contours of the search. And that was something that was discussed in the Georgia appellate case that recently addressed this issue, that talked about different types of folders on a cell phone and how you can go into some, but not necessarily others. That was Hawkins, I believe. So, thank you.
I'm going to give you 3 minutes for rebuttal.
Thank you, Your Honor.
And would you give the State 3 minutes extra, please?
May it please the Court, Counsel. Christine Gard on behalf of the State of Florida. The appellant has never contended that his arrest was unlawful, not based on probable cause. He's also never contended that he wasn't in an actual physical possession.
No, he's basically saying that that the search here was a fishing expedition.
No, it's not, Your Honor.
Why isn't it a fishing expedition? Because that's what it seems like to me.
The officer articulated a purpose in this case, and his purpose was
Well, the purpose is because some people might take pictures of themselves robbing something or pictures of the evidence.
I mean, wouldn't that allow you to look at a cell phone every time you arrested somebody?
Yes, and that's quite frankly what Robinson holds at this point in time.
Well, Robinson never contemplated cell phones.
I understand because it happened in 1974, but Fourth Amendment case law has been evolving over time and does not, it relies on certain basic principles that have existed since the founding of the Union. Robinson holds, along with Edwards and several other cases that come past that, that you can search incident to arrest any closed container upon that person.
So your position is that law enforcement, they arrested the defendant, they take the cell phone, they can open it up and look at pictures?
Yes.
They can look at phone calls you've received?
Yes.
Texts you've received?
Yes.
Emails you've received?
It's going to depend on the capability of the phone, and I mean, again, we're talking about this type of crime, not a driving infraction, because we do have cases like Knowles that say it has to be related to the crime charge. You can't pull something out.
Well, why in the case with the driving suspension can you say, well, he may have taken some pictures of himself driving with the date on it?
Yesterday there was an article on the internet of a gentleman that did a video of himself going 140 miles an hour on the interstate, and that was the evidence that led to his conviction.
Your Honor, I don't know what the facts of that case
Okay,
were. I understand.
but the point is, can't there always be evidence of a crime in your photos on your cell phone?
I suppose there could if you took photos of the proceeds of a crime on your cell phone. Most of us don't do that, Your Honor.
Well, you just said most of us don't do that. So the police should be able to...
Are you overestimating the average intelligence of Americans?
Yeah, first of all, you probably are, but I think you just... I just think you got hung on your own petard a little bit, because you said most of people will not do that. And does that not say that the police did not have some kind of articulable reason when you just said most people won't do that?
No, Your Honor. In this case, the officer tested, most people are not criminals either, Your Honor. So first of all, we're dealing with the officer in this case articulated his position, and his position was that he oftentimes finds, or he has reason to believe, that people who've engaged in this type of criminal activity often take pictures of the proceeds of their crimes. He articulated it. You can look at his exact articulation in the record.
Is that substantial evidence of that? Did he take surveys?
And I have to tell you that other than Bonnie and Clyde, and I know about that largely from the movie, I can't, in 19 years as an appellate judge and 6 years as a trial judge, remember a single case where evidence included somebody who had taken pictures of him or herself with evidence of the crime.
Your Honor,
I know there are some, but I can't remember ever seeing one.
Your Honor, we have a number of child pornography cases in which cell phone images are
Yeah,
used.
that's to me, that's a pretty different kind of...
Yeah, you know what? If we were up here on a child pornography case, and people had found a bunch of pictures already, and they knew about pictures, then I've got to tell you, I would say, right on, officer, go search that cell phone. But that crime lends itself to the fact that there may be pictures, other pictures and other evidence of child pornography.
And moreover, in those kinds of cases, the crime is possession of photos of children that are pornographic. It has nothing to do with the defendant necessarily being in the photos. It's mere possession.
But the defendant may very well have been in some of those photos.
But that wouldn't be the justification for looking. The justification would be the likelihood of evidence of the crime.
Your Honor, simply in some of those cases, a search incident to arrest, the defendant had the cell phone on his person, and like any other closed container, it was able to be searched by law enforcement because it was on his person. This is not a case where the cell phone was located at his house later, was found someplace, in the vehicle, which is now sort of restricted by
But
GAN.
you're going back to a test basically that says if anything on your person, no matter what, can be totally searched incident to arrest. I mean, isn't that basically your position?
That's basically the position of the state. Robinson explained...
Okay, well, help me. I'm sorry, I just raised my voice here. Didn't even mean to do it. Okay, help me here, because we have the case of Jenkins. And while Jenkins upheld the search, the Florida Supreme Court told us that we had to do a weighing test about the need for information versus the right to privacy. So Jenkins seems to indicate to me that not everything on my person, incident to arrest, can be totally searched. That's how I read Jenkins. Florida Supreme Court has told us that test has to be followed. Am I wrong?
Your Honor, Jenkins was amongst those strict search type of cases that limited an officer to where he could look at certain things and do certain things. In other words, you weren't to disrobe a person in public. You could do that back at the station. Nothing in Jenkins prohibits a strict search back at the station, if it complies with, obviously, the Florida strict search statute on top of that. But that is not the essential holding of Jenkins. Jenkins is only tangentially related to this case. It talks about things in a different manner there. And in fact, in Jenkins, they were allowed to lower essentially his trousers slightly because his boxer shorts were sticking out.
Well, they had information that that's where he was carrying his drugs.
And that's where correct. They were allowed to check his buttocks for drugs. They just couldn't.
But that's where they had information that there was potential evidence located where they were trying to search.
Well, they didn't have evidence. No, I don't believe that Jenkins stands for the proposition that the officers could search his between his buttocks. Because they had information that he might be carrying drugs between his buttocks. They did not find drugs on his person, and as a result, they chose to search there amongst other places.
Okay. Now, going back to the Schimmel case, the whole idea where all this came from, they talked about the justification for the search being basically the officer's safety and to preclude the destruction of evidence. Doesn't that, at least by implication, say there has to be the justification about the search for the weapons? That's always there. But doesn't that at least indicate that there has to be some potential, some level of evidence that there's evidence that could be destroyed, evidence of the crime
Again,
that the person's being arrested for?
Again, Schimmel is a different circumstance, but when you're looking at whether or not evidence could be destroyed, the fact that it's been seized, it's an electronic device. There's no way to know what will happen to it when its battery is discharged. It has a limited battery life. There's no way to know. Schimmel doesn't say if I have a diary in my pocket, you can't open it up and look inside of it. Schimmel doesn't stand for that proposition. This is an electronic container that contains the same information that I might carry in my purse, which is out in my vehicle. In my purse, I have a date book, my calendar for the office, my personal calendar. I have an address book contained in there. I may or may not have notes of things that I've done or am going to do, which would be akin to a diary, and I have a wallet in there. And there is nothing in the case law that prohibits taking in my wallet.
How about if the officers had gone through the phone and gotten onto the bank account of that particular person, of this particular person?
I think that at some point in time there's going to be a line that can be drawn. In this case, it is like the things that one would carry in their pockets or in their purse or on their person. But people don't carry, not all, that's where you start to get...
Do you ever have a bank statement in your purse?
Sure. And if it was open in my purse, then the officer could certainly look at it.
But they can't get on your iPhone and run your banking app and see how much you have in your account?
My banking app is password protected. They'd have to have my username.
So are you saying that that's the line we should draw, that stuff that's password protected on the phone? Is stuff the officer shouldn't be able to search absent some evidence of a crime?
I don't think there's any support for that in the current and existing federal law at this point in time.
I don't think there's a heck of a lot of federal law discussing this. And we're going to have to come up with some kind of test here.
Well, again, you shouldn't be reaching that. We don't know what kind of phone we had in this case. We don't have any information in the record as to the type of data it could store. We know obviously it can probably text message. We know that it's capable of receiving and returning phone calls because that's why the officer checked it in the first place, was to make sure it was the phone that he was being called from. And we know that it belonged to the defendant and it had the capability of taking photographs. So that's all we know about this phone. We don't know that this phone had any electronic capability beyond those functions.
Okay, can I switch back for you a minute?
Yes.
I want to go back to Jenkins again.
Yes.
And the reason I want to go back is I understand it had to do with the extent of the search in that particular case. But I want to read you a quote from it, if I could. The test of reasonableness under the Fourth Amendment is not capable of precise definition or mechanical application. In each case, it requires a balancing of the need for the particular search against the invasion of personal rights that the search entails. Courts must consider the scope of the particular intrusion, the manner in which it is conducted, the justification for initiating it, and the place which it is conducted. So at least part of the test, to me, of what's under Jenkins is the justification for making a particular search. Not only the extent of the search. So is there, again, address the justification for the search here?
The officer in this case indicated that it's been his experience that arrestees, people who've committed these type of crimes, take photographs of themselves and or the proceeds. That's exactly what happened in this case. The defendant took pictures of himself and his girlfriend with the proceeds of the crime and the weapon used in the crime. And the weapon...
And then I go back to you and help me here. Is the officer's assertion that sometimes people take pictures of themselves concerning a crime sufficient justification? How about if the officer says, I know some people that walk on water? And I guess my question goes to the competency of his testimony to support that proposition. Just because one officer from, and I don't remember where this officer is from. Duval County. Well, not picking on Holmes County, but they haven't voted for me recently, so I'll pick on Holmes County. Some officer from Holmes County that's been on the police force for 6 months says, you know what, I think a bunch of people take pictures of themselves committing crimes. Is that a reasonable justification for intrusion on the privacy interest of an individual?
Your Honor, I don't know how many people that Holmes County deputy would have arrested during that time period or what crime he would have been exposed to. But in a big city like Jacksonville, you have a lot of crime. There's no evidence that this officer...
Okay, help me here. Once we establish that this is a search without a warrant, who has the burden of demonstrating that the search was reasonable?
The state does, Your Honor.
Okay, again, I go back to even if we assume that he may be right, do we have a sufficient record here to support his justification for conducting the search?
Again, the court in this case apparently made a finding of fact that there was sufficient justification. The court was in the
But
best...
the court has to have competent substantial evidence to make that finding of fact.
The court had the officer before it, heard his testimony, saw the officer, and we all know that when we're in court and as trial lawyers and as trial judges, you oftentimes see the same officer over and over and over again. And that was not a claim that has been raised before this court. They've never argued that the officer didn't have sufficient experience. They have argued that you cannot get into the cell phone, period.
Well, they talked about the reasonableness of the reason given for the search here. I mean, that's not broad enough to raise those kinds of issues?
The officer provided a reasonable articulation for why he wished to look at the photographs. He had a twofold reason. One was to make sure the phone was the phone that he was being contacted from. And the second one was because people take photos of crimes after they've committed them. And that's exactly what happened in this case. Additionally, in this case,
Let me just stop you there and ask, as I understand your position, it is based on your reading of Robinson, all of that is irrelevant.
yes.
You don't have to have any articulable suspicion. A search incident to arrest is reasonable per se.
It is, under Robinson and
A
Edwards.
search of a person.
Yes. And even under Chadwick, which was the restricting, one of the ones that restricted it, by saying the footlocker was not within his possession, and as a consequence, once he had been removed from the location of the footlocker, you needed a warrant to get into the footlocker. Under, to the extent Jenkins is inconsistent with that, this court must follow Robinson and Edwards and the progeny that explains that articulation, because this was an item within his possession. Gant did nothing to change the
I was
availability.
going to ask you to address Gant. Because Gant, I understand it was a car that the person was nowhere near, but the Supreme Court at least again talked about the justification for the search in Gant. And, search incident to arrest. And again, they talked about officer safety and the potential for destruction of evidence.
Yes.
But
So
of
why-
course, in Gant, the items that were discovered were not on the defendant's person.
Correct. They did nothing to change the overall articulation from Robinson.
They broadened the area that could be searched. And they
Yes.
said that while a broader area could be searched, there have to be certain preconditions met first.
Right. Essentially, Gant restricted Belton searches upon removal of the defendant or the arrestee from that location.
So if I understand your position fully, it is that based on Robinson, which was decided some 9 years before Jenkins, the Florida Supreme Court is just wrong when it says you have to apply a reasonableness test to searches of the person incident to arrest.
To the extent that it conflicts with Robinson, Jenkins was dealing again with those strip search line of cases.
But it was a search of the person.
Correct. You could do strip searches back at the precinct or in the booking area where it was private, but you can't do it on the
So
street.
you're saying that all Jenkins stands for is that the procedure for the search must be reasonable. You can search, but you have to do it in a way that will protect an individual's privacy while you're doing it to the extent possible.
I think that is a possible interpretation of Jenkins. We may disagree
Is
on
that
that.
your interpretation?
I think that's the way Jenkins has to be interpreted, or, in that general
Or
vicinity.
you have problems with Robinson.
With respect to Gant, this court has held that the good faith exception is applicable to all pre-Gant searches. This is a pre-Gant search. Under Christy Lynn Harris, this panel is bound by whichever panel it was that decided Christy Lynn Harris. And as a result, the good faith exception from United States v. Leon says that that the officers are entitled to that good faith exception.
So the good faith exception applied. Does there not have to be clear law on the subject?
Yes. And the clear law is Robinson.
I understand that. So the Ohio State Supreme Court was wrong?
Well, the Ohio State Supreme Court conflicts with both the Georgia and California Supreme Courts. So
So when you have conflicting case law, that's clear legal precedent?
Well, again, Your Honor, Robinson is absolutely clear. The articulations of other courts leave it where it is. Everybody thought Belton was clear as well, and here we got Gant many, many years later. Additionally, in this particular case, the error was harmless because we have a defendant who robbed the place that he goes to every day.
What's the test under Giulio of harmlessness?
Harmless beyond to the exclusion of a reasonable doubt.
What it really is that there's no reasonable possibility that the jury could have considered this evidence in reaching its verdict. Isn't that the test?
Could have been influenced by this evidence in reaching its verdict.
And can we really say that in this case?
Yes. In this case, you had a defendant who robbed a convenience store that he went to every single day.
Okay, you're about ready to go through the overwhelmingness of the evidence of the guilt here.
And every time the third ECA uses that test, the Florida Supreme Court slaps them down.
And I understand that, Your Honor. The articulation in this case is that the jury didn't need this evidence, didn't rely upon this evidence, and reached it. I understand that Your Honor has a different position, and with respect to
my position is based on the Giulio. I'm not telling you I like it. I'm just saying I don't know how we can possibly say, to the exclusion of all reasonable doubt, that the jury couldn't have considered this evidence.
Going a little bit further, I'm not sure I love the Florida Supreme Court decisions that say the overwhelmingness of the evidence standing by itself can't be matched to the Giulio test, but that's what they told us. And from reading your brief, all I see is you're talking about the overwhelmingness of the evidence.
Your Honor, there's just, in this particular case, no question who committed this crime. And with that said, the State respectfully relies on its brief to any extent that we haven't answered a question in this Court, and respectfully request you affirm the conviction in this case based upon Robinson.
Thank you, Your Honors. To return to Jenkins for just a moment, we didn't brief that line of cases, but I would say that a principle that you could take from those cases is that if you read Robinson to allow any search without any restrictions simply because someone is arrested, that's reading Robinson too far. There are limitations even on a search of a person.
Let me read what the Court said in Robinson. We hold that in the case of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also a, quote, reasonable, close quote, search under that amendment. Does that leave any room for interpretation?
In the context of the changing circumstances that this Court's presented with, yes, because the type of information that we're talking about searching now was simply not contemplated by a search of the person at the time Robinson was decided.
Can we say to the United States Supreme Court, your language was clear and unambiguous, but you weren't thinking about cell phones at the time, so we don't think it applies here?
Yes, Your Honor. Respectfully, I believe you can, and I believe that's what the vast majority of cases that have confronted this issue have done. If it were so clear under Robinson that anyone carrying a cell phone has given up all privacy in the contents of that cell phone, there would be no need for any of these decisions to discuss the reasonableness of the search or the analogy to a container. Regarding the reasonableness of the search, I just want to point out to the Court that the officer's justification for doing the search in this case was that it was not unusual for a suspect to have photos of evidentiary value. He was asked, is it unusual for a suspect to have photos of evidentiary value? He said, no, it's not unusual. Did you find anything of evidentiary value? Yes, I did. So it's using the fact that he found photos of on this phone that happened to appear to relate to the crime to justify the original intrusion, which is not the type of connection between the phone and the crime that supports the intrusion into the phone.
Let me get back to, was there any objection raised as to the competency of that evidence, or that was a conclusion that the officer couldn't draw?
Your Honor, the objection was not phrased in those specific terms, but it was challenged in terms of the reasonableness of the search, which is a fact-specific inquiry that would depend on that, among other circumstances surrounding the search.
Okay.
But of course, if the state's reading of Robinson is correct, all of that's irrelevant.
Your Honor, if you interpret Robinson to allow a search of any electronic device that a person happens to be carrying, which would include a laptop or a variety of devices, then the analysis changes. Yes.
Okay, thank you.
Thank you, Your Honor.
Okay, thank you. Well argued on both sides. Thank you.